on tariffs. We have done several podcasts before, but this one is a new development, covers a new development. And greetings from Washington, D.C. My name is Axel Spies. I'm an international attorney based here in Washington with Potomac Law Group. And I have the privilege to introduce Michael Negro here for our podcast. And I let him introduce himself.
Thank you, Axel. That's a kind introduction. My name is Michael Del Negro. I'm a regulatory and trade compliance attorney who has recently come off of 15 years of corporate practice, helping companies that manufacture consumer products and electronics navigate the world of product regulation and trade, which is, as everyone knows, booming right now.
So yes, we have a great development here, and that is coming again from the courts. And we are talking here about the U.S. Appeals Court's decision from Tuesday that temporarily paused a lower court ruling against the Trump administration's 10% global tariff under Section 122 of the Trade Act. And maybe we start by flagging what is actually covered. What is Section 122 by the Trade Act, and how is it different from the earlier the tariffs that were subject to jurisdiction? Would you take that?
Sure, I'd be happy to. So the Section 122 of the Trade Act deals with the so-called balance of payments. And the administration sought to replace this very quickly, or put it in place very quickly after the Supreme Court in Learning Resources struck down the IEEPA tariffs. And just as a reminder, the IEEPA tariffs included fentanyl tariffs for concerns related to the import of fentanyl and other drugs from China, Mexico, and Canada, and then so-called reciprocal country tariffs. In February, that scheme was struck down by the Supreme Court, and the same day the White House issued its proclamation on, as Axel said, the Section 122 tariffs. And the main difference is the Section 122 tariffs are kind of a blunt instrument. They are meant to go into effect for about 150 days, or exactly 150 days, and to deal with financial payments issues where there are more outflows of US dollars than inflows, with the policy goal of protecting against the devaluation of the US dollar. And I'll stop there and just see if there are any further questions, but that is the main difference.
Yeah, thank you. This tariff was subject to a U.S. Trade Court ruling on Friday that ruled against the new tariffs, and then the Trump administration appealed. Where do we stand in the process right now?
Yeah, it's a great question. And for importers who are wondering where things stand, let me try to unpack that a little bit. The Court of International Trade issued an injunction with respect to the state plaintiffs, and specifically with respect to the state of Washington. So not all importers get the benefit of that decision. That's one key point. And then on appeal, the Federal Circuit has stayed the court's injunction, and the court, for reasons that are a little longer to explain, was reluctant to impose a so-called universal injunction. And that's something that's come up earlier this year in court cases where district court judges sought to impose nationwide injunctions. So with the state of play, as I understand it, Axel, is we have an injunction as it relates to the state of Washington, and that has been stayed pending next steps at the Federal Circuit.
Yeah. Very good. Yeah, if people are wondering why the state of Washington is qualified as an importer, I understand that the state of Washington paid tariffs to the University of Washington, and that's a public research institution, and that's why they have standing in the court.
Yeah, that's right. And it raises a really good question that I'll just touch on, which is who is an importer and which parties are entitled to obtain refunds, either in the IEEPA case or in eventually the outcome of this litigation against the Section 122 tariffs. And just as a reminder for folks who may not be steeped in this area, tariffs are a tax that the importer of record pays on imported articles. And in some cases, those costs are passed on. In some cases, just the importer absorbs them. But they are not a tax on a foreign supplier unless companies negotiate that separately.
Yeah, and that we discussed already in earlier podcasts, but it's worth repeating. Importer of record, what that is, it can be another party, right? It doesn't need to be what we think is the importer. It must be the importer of record.
That's right. The importer of record is a defined term, and it is the party that assumes responsibility for compliance with customs laws, valuation of the goods, declaration of the tariff classification that applies to the article, and making sure that those amounts are accurately valued and disclosed in the entry form. And the entry form itself is the 7501 that the broker may complete, but the importer record is the legal entity, can be a person, it can be a company, who is responsible for compliance with payments, including payments in connection with tariffs.
Yeah, and coming back to the tariff itself, I understand that the 10% global tariff is scheduled to expire in July unless extended by Congress.
Yes, that's right. And that date is significant for a couple of reasons. As I said earlier, it's the Section 122 tariffs are a bit of a blunt instrument. They are meant to deal with a short-term payments problems where there are more outflows of US dollars than inflows. The July expiration date, Axel, happens to coincide with when we expect to see investigation findings in a set of new investigations the administration has started under a separate regime, the Section 301 investigations. And there's two sets of those, but they also have a July 24th, 2026 date when we expect to see at least findings and maybe imposition of new tariffs in connection with those investigations into additional countries.
Okay, so there's more action that's probably coming. The main question that our listeners will probably have is, will importers get refunds, and when will that happen here? Is that the same as in other cases?
Yeah, and this is obviously a key question. Of course, we know that there's a refund process that CBP has set up in connection with the IEEPA tariffs. Those are underway. And there's an administrative process that CBP is overseeing so that importers of record, again, who are eligible to obtain refunds and have a declaration and can meet all the requirements, are able to apply and obtain a refund. That process is ongoing. So we know it's possible. The question here is, what is the resolution of the litigation challenge? This is a different scheme than the IEEPA tariffs and a different basis for invalidating them at the trial court level. So it's a question of how long does this litigation play out and what comes next? And that's a little bit uncertain.
Yeah, but is it possible that the tariffs will be retroactively invalidated?
We know that was the case in connection with the IEEPA litigation. In other words, importers who had previously imported after the April IEEPA tariffs were imposed a year ago were in fact eligible for refund in that scenario. So yes, they should be available retroactively. That's the nature of the refund process. I'll just mention quickly in connection with that, Axel, there is a process called liquidation, and that normally takes about 314 days for the ultimate liability for an importer to resolve in terms of how much duties, interest, tax are owed to CBP. And within the window before liquidation occurs, and it can be extended upon request of an importer, it is easier to get a refund. After liquidation, after that period has expired, importers are still eligible for refunds, but they have to file a protest, and there's a defined period for doing that as well. So not to get in the weeds too much, but there is a window where importers want to look at the schedule for how long it's been since their product entered the US, what the entry date deadline is with respect to seeking refunds.
Yeah, thank you. This is an important point for our foreign listeners, in particular, because the term liquidation is not what you originally think. We think about liquidating a company, for instance. We know what that is, liquidated damages, but that is not what we are talking about here, right?
That's right. Yeah, liquidation is when a broker submits an entry form and there's an estimate of what the duties and taxes are owed, and those duties could include Section 301 tariffs, MFN, and other expenses. That amount is not really settled until liquidation is done. So all of those costs really aren't crystallized until liquidation occurs, and then it's that point that the liability is really finally settled, if that makes sense.
So what about this strategy? So someone says, all right, with the tariffs, the Trump administration will find other reasons to impose tariffs. So I move some of my production to Mexico. That's a market that is very attractive. Maybe the rates for workers wages for workers are lower. Would that be an option here? Is moving production to Mexico enough?
Well, it depends. It's a really good question. It's really a question about USMCA or USMCA, depending on how you pronounce it. And this is the trilateral trade deal that gives preferential treatment for importers that can meet eligibility requirements with respect to goods that are eligible. And that's a little bit complicated. It's very fact specific. It depends on how much regional content the supplier is able to satisfy. And in general, that's a great option if companies can manage that effectively. Of course, USMCA is up for review this year, I think also in July. So this is a consequential window we're in between now and the summer months, where some of these tariff measures will be resolved. The USMCA review will kick off. That could invite further changes to how USMCA works. And some of the three countries may have issues that they want to put back on the table in connection with that review. So this is, at least for the world of trade, an exciting little window of time.
And when companies are asking, what do you think, which industry are mostly exposed, which industry are mostly at risk that they fall under the tariffs, and what should they do to determine that?
And with respect to the Section 122 tariffs, so there are some exclusions. Pharmaceuticals are accepted, and there's some other exceptions for certain electronics. So companies and their counsel have to look carefully at the scope and understand which tariff codes and SKUs are in scope of the Section 122 tariffs. Of course, the litigation has sort of upended that a little bit, but the tariffs remain in effect while the appeal is ongoing. I think we said that before, but just to be really crisp on that point. And companies that produce consumer products, pharmaceuticals, raw materials that are imported for U.S. production, many of the tariffs apply, and there's a separate section of tariffs called the Section 232 tariffs, which focus more on national security, not on unfair competition. And they apply not on the country level, but on the product level. And that is another tool in the arsenal of the administration to impose tariffs sort of sector by sector or on materials like steel, aluminum, copper, pharmaceuticals. And so that's an area that needs to be looked at carefully as well.
I understand that there are at least 2 pending Section 301 investigations going on right now. Can you elaborate on that a little bit, what that is all about?
Yes, I mean, the one view is that the administration recognized the Section 122 tariffs simply as a stopgap measure to bridge the time it would take to conduct the Section 301 investigations. So as you point out, there are 2 parallel sets of Section 301 investigations. These deal with country-specific trade practices that the U.S. are concerned could involve unfair competition with the U.S., sometimes related to forced labor, sometimes related to what's called excess industrial capacity. And there's a host of countries, I think 16 countries that are being looked at with respect to their trade practices. These actions have a little bit more durability. They're on a firmer legal foundation. They've been challenged unsuccessfully in the past. So unlike the IEEPA tariffs, I think most in the trade community feel that the Section 301 tariffs are on a firmer foundation. But also, I think that the findings are due by July 24th. So we're at the same time that the Section 122 tariffs were going to expire. The administration could be ready to announce a new tranche of tariffs at the country level for those sets of matters.
Fantastic. I mean, everything we are doing right now is to give a snapshot of where things stand, and things can change very quickly. Our intention is to come up with more information later. But I think that was a very good overview as to what is happening right now. And we're more than happy to answer questions. So feel free to talk to us here in our group. We are more than happy to help you out. We have a good team working on these issues. And other than this, we probably will be back when there is more on the appeal process, and that we can share with you, and hope that in the meantime that this is what information that we gave to you is helpful. And so we hope to talk to you and see you back with a podcast soon.
Great. Axel, thanks so much.
Yeah, thank you very much, and thank you for listening, and until next time then.